Do remote workers have the same rights as office workers? Remote work is now everyday life for millions in the U.S. Some people work entirely from home, others split time between home and the office. That raises a constant question. Do remote workers have the same legal rights as office workers? Maybe you're on the couch wondering whether overtime still applies. Maybe the home setup is causing pain and you're asking, does O.S.H.A protect me here? Employers sometimes treat remote staff as a special category, but the law doesn't always agree. In this video, we'll break it down clearly. How wage and hour rules apply to remote work, what safety and privacy rights exist, how anti-discrimination laws protect remote workers, and where the limits are. By the end, you'll see exactly where remote and office rights overlap, and where gaps and challenges remain. Remote workers are generally covered by the same core protections as office employees. What changes is how those protections apply when the workplace is a living room, a kitchen table, or even a coffee shop. To make things clear, let's walk through 9 key areas that define remote worker rights. 1. Wages and hours. The F.L.S.A. still applies. The Fair Labor Standards Act, F.L.S.A., sets baseline rules for minimum wage, overtime, and record keeping. Those protections cover most employees, whether they're in a cubicle or at a kitchen table. Minimum wage still applies. Employers must pay at least $7.25 an hour federally, or more if state law is higher. Overtime still applies. Non-exempt remote workers get time and a half for hours over 40 in a work week. Record keeping is the employer's responsibility. The Department of Labor counts all hours an employee is suffered or permitted to work, even if done remotely. Example: a customer service rep answers emails after dinner from home. If that pushes the week over 40 hours, overtime is owed, even if no one explicitly asked for the extra time. 2. Safety. How O.S.H.A treats home offices. The Occupational Safety and Health Act, O.S.H.A, requires employers to provide a workplace free from serious hazards. Home offices are different, but protections still exist. Employers do not have to inspect or maintain your home office. Employers are responsible for hazards tied to the work they assign. Equipment they provide must be safe. If employer-provided electrical gear injures a worker, O.S.H.A can get involved. Example: a call center employee develops wrist pain due to poor ergonomics. While O.S.H.A won't inspect the home, the employer may need to supply better equipment or reasonable adjustments. 3. Anti-discrimination. Equal protection remotely and on-site. Title VII, the Americans with Disabilities Act, ADA, and the Age Discrimination in Employment Act, ADEA, protect remote and in-office employees alike. No discrimination in pay, promotion, or treatment based on protected characteristics, regardless of location. The ADA requires reasonable accommodations in remote settings too, adaptive tech, flexible schedules, etc. Retaliation bans apply equally. Example: a remote employee is passed over for promotion while in-office peers advance. If the reason ties to gender or stereotypes that remote workers are less committed, that can violate Title VII. 4. Collective rights. The NLRA covers remote workers. The National Labor Relations Act, NLRA, protects employees' rights to discuss wages, organize, and join unions. Remote status doesn't erase those rights. Workers can discuss pay and conditions and can organize digitally. Employers cannot surveil or retaliate against remote union activity. The NLRB recognizes that email and other electronic channels can be protected spaces for organizing. Example: remote tech workers open a Slack channel to discuss unionizing. Management can't lawfully shut it down or punish participants. 5. Privacy and monitoring. ECPA and state notice rules. Remote work amplifies privacy concerns. Monitoring tools track keystrokes, screenshots, even webcams. Under the Electronic Communications Privacy Act, ECPA, some monitoring is allowed for legitimate business purposes. Several states add stricter rules. Connecticut, Delaware, and New York require notice of electronic monitoring. California's constitutional privacy right may limit overly intrusive surveillance. Example: a remote employee discovers 24/7 keystroke and webcam logging with no prior notice. Even if ECPA might permit business purpose monitoring, lack of notice can violate state law. 6. Benefits and leave. Location doesn't cancel. Eligibility. Benefit eligibility often follows hours and employer size, not office presence. The Affordable Care Act, ACA, requires large employers to offer health insurance to employees averaging 30-plus hours a week, regardless of where they work. The Family and Medical Leave Act, FMLA, can cover remote workers if tenure and employer size thresholds are met. Paid sick leave depends on state or local law, e.g. California, New York, Massachusetts. Example: a remote worker in California is entitled to state-mandated paid sick leave just like an on-site colleague. 7. Taxes and which state's laws apply. Remote arrangements raise tax and jurisdiction questions. Many protections hinge on where the work is physically performed. A New York resident employed by a New Jersey company may owe taxes to both states unless a reciprocity agreement applies. Wage and hour rules, overtime, meal, rest breaks, generally follow the state where the employee actually works. Example: a California-based remote employee working for a Texas firm is entitled to California's stronger overtime and meal break rules. 8. Real-world outcomes. F.L.S.A. back pay. A remote call center worker logged 50 hours but was paid for 40. DOL enforced overtime and recovered back wages. ADA. Accommodation. A disabled remote worker requested assistive software. The employer refused. The EEOC found a violation. Accommodations apply to remote roles too. Monitoring notice. A New York remote retail worker was monitored by hidden software. Without written notice, the employer violated state law. Online organizing. Remote editors formed a digital union effort. Attempts to shut down their Slack channel were unlawful under the NLRA. 9. The big picture. Remote work hasn't erased core employment protections. Minimum wage, overtime, safety, anti-discrimination, and collective rights still apply. What's evolving are the edge issues: digital surveillance, multi-state tax rules, and how to ensure safety in homes the employer doesn't control. The guiding principle is simple. Remote workers are employees, not exceptions. Rights travel with the worker, whether in an office chair or at the kitchen table. Do remote workers have the same rights as office workers? Mostly yes. The F.L.S.A. still guarantees minimum wage and overtime. O.S.H.A. still requires safe tools. The ADA, Title VII, and the ADEA still ban discrimination. The NLRA still protects organizing. Benefits and leave laws apply when eligibility is met. Differences arise with state laws, privacy limits, and tax rules. If policies treat remote workers as second class, the law often says otherwise. Share this with your team. Remote work is here to stay, and knowing the rules keeps things fair wherever we log in. So, do remote workers have the same rights as office workers? In most cases, yes. The F.L.S.A. still guarantees minimum wage and overtime. O.S.H.A. still requires employers to provide safe tools and equipment. The ADA and Title VII and ADEA continue to ban discrimination. The NLRA protects organizing and collective rights, whether workers are on-site or online. Benefits and leave laws apply if eligibility requirements are met. The differences come in new areas: privacy, digital monitoring, state laws, and taxes. Employers may try to treat remote staff as exceptions, but the law says rights follow the worker, not the building. If this video helped clear things up, share it with coworkers. Remote work is here to stay, and knowing the rules keeps the workplace fair, wherever we log in.